close that stop.
BlastMusic247.com. We're changing the industry, one artist at a time.
Hello, friends. Happy Thursday. It is time for the Legal Lounge. We have a busy episode this week. We are talking about divorce, custody, and child support. So, that's a topic I get a lot of questions about. So, I thought I would cover that. And before I get started, I'll introduce myself for anybody that's new to the podcast. I'm Nichon Mitchell. I am an attorney licensed in Tennessee and Mississippi. My Texas licensure is pending, and I am a licensed real estate agent in Texas. I've been a real estate broker in Mississippi, and then I have an insurance license for Texas and Tennessee. So I am full service for my estate planning clients who need insurance, who need their houses put in trust, and who need legal work. And so that's kind of what I do. Alrighty. So I hope you got your pen and paper ready. I posted that on some of my platforms today that this is going to be jam packed with a lot of information. And so we're going to jump right in and we're going to start talking about divorce. So I'm mainly going to, when I talk about specific law, I'm going to talk about Tennessee and Mississippi because that's where I have a license. But what I want you to know is no matter where you are, and if you'll be so kind, wherever you're at, drop your state in the comments so we can see where you are. But there are certain things in American law that there's a common theme that runs across all states. It's just they will implement that in a different way. Like there's certain things with custody and certain things with marriage. And so while you may be in a different state and it looks a little bit different, what I'm going to talk about is common themes, give you some tips and some things to do and think about if you're in one of these situations of divorce, custody, or child support. So, and I have if I'm able, I practice sharing the screen. Hopefully it'll work, you guys, because especially when we get to the child support and custody part, I found some really good statutes in Illinois that are a good example of what I'll be talking about. And then I saw another one in Ohio that's very much the same. And that's just an example of what I'm saying. The general principles apply across the country, but states just have their own little specific parts to it. Now, that being said, Louisiana is always going to be different. Louisiana is the only state that is Napoleonic Code. It is not common law, Old English law like the other 49 states. So Louisiana is always going to be very different. I don't know anything about Louisiana. When you go to law school, you don't learn anything about Louisiana. They do their total own thing. But I welcome my Louisiana people. And I do still hope you'll stick with me because we'll have a lot of other topics. I'm going to do how to start an LLC, how to read a lease and contracts, and we'll have a lot of topics in the future. Okay, so hello. I see a lot of people chiming in and they're coming in on the comments. But like I said, drop your state in and then we'll get going. So this is what I want to say about divorce. And really, it's going to cover divorce, child support, and custody. Try to work out an agreement beforehand before you start any litigation. Now, friends, understand, judges and courts, they don't want to decide your mess. They want you to decide your mess. Judges don't like ruling on your conflict. Guess what? They don't know you. They've not met you before. And just imagine being dropped into the middle of someone's mess. And then you have to decide, where do these kids go? Who gets the money? Who gets to live in the house? I mean, they would rather you solve your own problems and come up with your own solution. Now, if you notice, a lot of times my podcast, I refer to what the rich or the wealthy people do. If you notice, a lot of times when rich people get divorced, all you hear in the news is they got divorced. And when the media tries to go get the pleadings, all that's on file is the actual filing for the divorce, and then a document that says they've reached an agreement and this file is closed. So you can have a private agreement that you and your spouse or the other parent come to, you can have a private agreement that most likely, unless it's just out the way crazy, most likely the court, will agree to, because they want you to solve your own problems. In the event you can't agree, that's when the court is going to step in and start making decisions. And 9 times out of 10, folks, you're not going to like what's decided. What I'm going to show you, if I can share my screen, if I can, I'm gonna describe it for you, is every state has the state laws. Every single law in the state is captured in one place. In Tennessee, it's called the Tennessee Code Annotated. In Mississippi, it's called the Mississippi Code Annotated. But like in Kentucky, it's called the Kentucky Revised Statutes. And so different states will kind of have a little different name, but when you see that, that's the every single law for that state. And you, as a citizen of the state, you are charged with knowing every single thing that's in there. But they lay out all of the laws about marriage, custody, divorce, and all of the laws are there. So a lot of what goes on in cases, as attorneys and judges, we are not making it up. We have to go by what's in the statute. And I'm going to show you guys where the statutes are at. So, the biggest thing to get out of this is have a plan before you get divorced. So, what does have a plan mean? Before you even file, um, understand your budget. Where are you going to live? Where are the children going to be? Or what's going to happen with assets and property? A lot of times people just up and file for divorce and nothing's been thought about. But you want to have a plan for your money and for your kids, for your property, your job, whatever. Are you moving? All that kind of stuff. So you want to have a plan. An attorney can help you with that. Um, the other reason to have a plan, okay, women, all my girlfriends out there, listen to me. It's a new day, okay? When I tell you women are paying child support and women are paying alimony, they are. You want to think about it if you've been the primary wage earner or if you make as much or more money than your spouse. You want to think, wait a minute, am I going to be paying him alimony? So you want to have a plan. A lot of times we know what's coming and we should not ignore what we think is coming. So if you even think you are 1 year, 2 year, 3 years, 4 years, women are real good about this, away from a divorce, start thinking about that and start planning. Um, Picking an attorney. I usually tell people to get a female attorney because they're usually more vicious, just being honest. They are usually more on top of things. Usually, male attorneys like to let a lot of stuff go, and I don't feel like they fight as hard. But you definitely want to get an attorney that understands the court process, that has appeared in front of the judges before, that you feel like you have a good working relationship with, that will listen to you and that will help you get what it is that you want. As long as a client asks an attorney to do something and it is not illegal, immoral, or unethical, we are pretty much obligated to do what the client would like. What I do when my client wants me to do something that I think is not a good move, but it's not illegal, it's not unethical, it's just I think strategy wise is bad, or I think it's not a good decision. I write them a letter that says, okay, client, you want me to do this. We've had this talk. I don't think you should do it, but I'm going to do it. Please sign this letter because I don't want that to backfire. That's more so for my malpractice insurance, or more so if there's a dispute in the future, then I'll be able to say, I told the client that wasn't a good thing to do when if they want to sue for malpractice or say I gave them bad advice or do something like that. Now, I've never had that happen. Don't have clients that I've had that problem with, but I just still do that. So I just said that to say, attorneys are charged with the legal aspect of the case, but that means I use the law to effect what it is that you want. Okay. So the grounds for divorce in pretty much the same in Mississippi and Tennessee, and these are pretty much going to be the same throughout the country with some small variations. Like Mississippi has 12 grounds for divorce, Tennessee has 15, but they're all pretty much the same. They include things like natural impotency, Of course, adultery, habitual and cruel and inhumane treatment, habitual drunkenness, if one of the spouses goes to prison, if you find out they were married to someone else. Now, watch this one. This one's tricky. If a man marries a woman and he doesn't know that she's pregnant, he can get a divorce. But now watch this. I didn't say if he don't know whether or not the baby is his, because a lot of times men will say, yeah, she was pregnant, but I thought it was my baby. That don't count. You had to not have known that she was pregnant, period, at all. Because sometimes, let's be honest, back in the day, what women did was about 4 6 weeks in, you pregnant, and they would up and get married, and then but even if the man knew they were pregnant, they would get married, right? And he's thinking it's his baby. 18 years later, he found out it's not his baby. He like, I didn't know that it wasn't mine, but I knew she was pregnant. That doesn't count. He had to have not known that she was pregnant. Okay, so different. So there are other reasons, of course, but those are kind of the main ones: cruel and inhumane treatment, adultery, um, desertion for a certain period of time, either 1 or 2 years, depending on where you are, and natural impotency and different things like that. Like I said, now, so check this out: irreconcilable differences. In Tennessee, they call that can be a ground or it can be a whole separate action. So in Tennessee, they have what's called, you can get a unilateral divorce. That means two people are married and one person says, I'm not happy. And the other person says, well, I'm happy. I still love you. This one person can still file for divorce under irreconcilable differences. In Mississippi, you have to have grounds to get a divorce. If you don't have one of the 12 grounds, the only way to get an irreconcilable differences divorce is if both parties say they not happy. Now, that's how you end up holding somebody hostage. So we may all know somebody, or we know some old heads at this time that they been married for 30 years, but they never lived together because one person won't agree to the divorce and otherwise they don't have grounds. So it says in the Mississippi statute that the the complaint has to be a joint complaint for irreconcilable differences. The statute in Tennessee doesn't read like that. So one party can file for irreconcilable differences and push a divorce forward. Just like in Mississippi, you can still sue for alienation of affection. That means that someone turned your spouse's affection away from you and basically stole your spouse, right? You can still sue for that in Mississippi. In Tennessee, you cannot. They abolished it in 1990. The Supreme Court said, we don't feel like somebody else can alienate your spouse from you, but your spouse goes willingly with that person. So that's how, there's some differences, but what you need to know then is you need to know the county where you want to file your divorce, and you have to get your spouse served. Those are things you need to think about and talk out with an attorney. This is part of the planning, because people may have issues where the spouse is not in the jurisdiction, he or she is in another state, and that kind of thing, and you have to work that stuff out. So the statutes provide for how you serve your spouse if they're in another state, how you serve your spouse in another county, where you can file the divorce if you two are not in the same household and you haven't seen each other in 1 or 2 years. That being said, too, in Tennessee, one ground for divorce is you've been separated for 2 years and you don't have any children. So that's a grounds for divorce in Tennessee. Trying to kill your spouse, the other one, that's a grounds for divorce. So like in Tennessee, when you file, you have to leave it on file for 60 days if you have no kids, 90 days if you have kids, and then you act on it. But in any event, what you have to do is basically have a trial on the grounds for divorce. So I've done more Mississippi divorces in Tennessee. Really, I don't even do contested divorces because I don't like being in the middle of people's mess. If people can agree, I will do it, but I don't do contested ones. But I've sat in court waiting on my case and watched some cases, and I saw a case where a woman had she had emails and every text messages and everything about her husband and another woman, and the court still didn't grant her divorce for adultery. It's kind of hard to get a divorce in Mississippi, in if you have a trial, um, because they favor marriage, especially a state like Mississippi favors marriage, and so it they don't just let you stroll in there and get one. So you have to know these things and these guidelines where you're living at. And so what happens a lot of times is people come to an attorney and say, well, my girlfriend got this, or my friend got this divorce, or my girlfriend getting this much child support, why I'm not getting that much. The other very, very important thing I want to impress upon people is every case is different. It may sound like the same case when your friend is talking to you, but it's not. And sometimes what it is that friend or that person is not telling you everything. They've left something out. Um, why you think your case sounds like their case, and why am I not getting that much child support? Why am I not getting that much alimony or whatever? The cases usually are not the same. Every case is different. It's very fact specific. Just like your life is different from their life, you're a different person from them. Every case is different. And it may sound the same, but I would caution people, do not compare your case to anyone else's case thinking you're supposed to get the same outcome. It's very fact driven. So, let me see, what else do I want to tell y'all about divorce? Let me see. Okay, if there's questions. Okay, I don't see any questions yet. Okay, so, um, okay, so so when you're doing this property settlement agreement, because see in Tennessee, a lot of times your divorce will go easy if you have the agreement really anywhere. But if you have the agreement already done in Tennessee, that makes your irreconcilable divorce go faster. If you don't have an agreement already done when you file it, the court is going to not approve the divorce and wait for you to get that agreement in place. What kinds of things should you be agreeing about? Everything. I mean, and then you have to contemplate the future. This is going to depend on whether you have children or and how old they're going to be. So, I'll use myself as an example. When I got divorced, my kids were 12 and 15. Um, we did the agreement outside. The judge didn't decide anything. And so this is the other thing. We haven't got there yet. But in Mississippi, you get child support until the child is 21. The age of majority in Mississippi is 21. So the way I had mine structured, there was no child support, there was no visitation restrictions. He could get the kids anytime he wanted them. He didn't have to ask for anything like that. This is how I wanted to do mine for moving forward in my life. There was no child support set because we were married for 16 years. And after that amount of time, when the kid's birthday is, when school is starting, what Christmas is, what they need. And they were old enough to call their dad for what they need. So my personal philosophy is they either gonna do it or they're not. And so I just disengaged from child support because I don't. So anyway, I didn't have any problems with him. He always did whatever was asked, whatever they needed. I didn't have any issues. So that worked out in my scenario, right? So, but so the judge was like, okay, your kids are 3 years apart. One is gonna age out. Even though I didn't ask for any child support, she was like, do you want child support for the 3 year difference from when the first one ages out to when you have the second one? Nope, I don't want any. That was just me, right? But so what I'm saying, and that's when I said earlier, you can craft your own agreement, and as long as it's not really crazy, the court will approve it. I mean, so I just said when we got our divorce, there was no child support set and there was no visitation restrictions. I mean, because that's what we agreed to. And now did the judge have some considerations? Well, yeah, but the judge understood, okay, well, mom's a lawyer, dad's college educated, accountant, real estate agent. they have enough money to make this work. And so the judge wasn't really concerned about the kids being taken care of. If there's a real genuine concern about the kids being taken care of, the court may ask some questions, or will ask, or will put something in the order that maybe you all didn't agree to. But for the most part, a court is going to honor what two people say they want to do. That's why it's important that you come up with an agreement about schooling, where the child will live, who pays for extracurricular activities, and who's paying for stuff. If you have to travel, who pays for the travel? Any and everything you can think of, you need to include in that agreement. Now, let me tell you what's also a something that's common amongst all states. And if I can pull these statutes up, I'm going to try to do it in a minute. You'll see the court is going to try to maintain the same situation of your intact family. So the way American jurisprudence is, the American law, when it comes to divorce, is courts are going to try to maintain the same situation as close as they can when a family is breaking apart. So they gonna try to keep that child living in the same standard that they was living in when the parents was together. They're gonna try to keep the same schedule, the same schooling, the same this, the same that. Now, to the extent that things are gonna change, because now somebody has to move, or the kids in a different school or whatever, the court is gonna work with that. But in terms of like child support, visitation, custody, all that kind of stuff, the court is going to try to maintain as close a situation to the intact family as it can. That's what the court will do if you leave the decision to the court. So that's another reason why you want to try to come to an agreement with the other parent and try to work together as best you can, because a lot of people get unhappy with what happens in court, but a lot of times you don't leave the judge any option. And so that is another reason to go ahead and try to get an agreement. Hold on, I got some statutes that I had pulled up. So let me see if anybody has questions about divorce. Let me see. I don't see any yet. Okay, so yes, if you guys have questions, make sure you drop them in. So I'll just keep talking until then. Okay, I don't have any more notes on mine about divorce. That's good, because I'm at my 20-minute mark for that. Okay, so let me tell you this part. I'm sorry. Legal separation. So a lot of times we use our words loosely as regular common people, right? But really, like Tennessee has a statute for legal separation. You can legally be separated. Go to court, ask the court for a separation and to provide alimony, child support, maintenance while you're separated. And maybe the parties are trying to figure out what they want to do. There is no statute in Mississippi for that. So some states have a statute for legal separation. Some states don't. That's why sometimes, depending on what business you're engaging in or what transaction you're trying to do, they'll say, the paperwork will say, are you legally separated? So, so the legal separation part, you have to know in your state whether your state recognizes legal separation. So, and I see the question. Hold on one second. I want to make sure that I got. I want to talk about real quick the defense to adultery. Some states will not. A lot of states. You cannot prevail on the cause of action on the divorce grounds of adultery if you went back into the marriage. So that is something. So once again, remember I said you got a plan. You have to have a plan. So you might need to talk to an attorney. And so a lot of times as women, okay, and to be fair, look, men too, but this is just the example. And then I'm gonna answer that question that was up, because it plays into this. A lot of times as women, because men a lot of times don't tolerate cheating and adultery the same way women do. So women, like, he'll cheat, we'll come back, whatever. And then by the third or fourth woman, we mad, right? We upset. So we like, I want a divorce for adultery. But in a lot of states, that can't be your grounds. if you have gone back into the marriage or if you stayed with the person, that kind of thing. So you want to know that beforehand, which is one thing, bouncing back to Mississippi, why the only grounds they have for divorce is adultery, but now they can't use it because they kind of went back into the marriage. And then the husband won't sign off on a joint complaint for divorce. So they're stuck. So the question was, do are judges more in favor for women than men? Let me tell you something about that for divorce, child support, and custody. So, in terms of custody, not there used to be, there is a doctrine called the tender years doctrine. And what that is, it was a presumption that for a child between 0 and 7 years of age, the mother was the best parent for that child. It was a presumption that the father had to overcome, and it was almost impossible. If the child was 0 to 7, definitely going to mom. Then after 7, there was still a high presumption that mom was the best parent. That is, most states have said they are not going by the tender years doctrine anymore. And a lot of states now, I'm just seeing a lot more men getting custody and a lot more women paying child support. And in some instances, like I said, even paying alimony. I will I want to be very clear and say so that is a lot of times because of antics that women will engage in. I have told people that call me, told my friends, told my family, look, child support and visitation, those are two different things. You cannot withhold visitation because someone is not paying child support. Man or woman, either side, whoever's got the kid, you cannot withhold visitation because someone's not paying child support. The remedy for somebody not abiding by an order is to do what's called a show cause or contempt action. So if someone is not paying child support, you still got to let the child visit, but you file a contempt action or a show cause. I always tell my clients and people that call me for advice, you don't have to fight and wrangle with the person. Where my money? Where my money? Or when you gonna visit? All you got to do is file that contempt action or show cause, and that makes the person go in front of the judge and explain to the judge why they're not doing what the judge ordered be done. Why aren't you paying your support? Why aren't you visiting like you're supposed to? Why are you refusing to pay half of the medical expenses? Whatever it is, right? So I always encourage people, this is the other thing you need to plan for when you know you want to get a divorce. Keep your lawyer paid. Keep your lawyer paid. Because I usually say let 3 instances of something happen and then do that show cause. Unless it's something really important, you do it after the first one. But if they're missing child support payments, if they're not visiting, then you want the order followed. You do that. Judges are switching custody to the other parent when one parent deprives visitation. There's a case in Mississippi where the child was 16 and decided she didn't, she had a life. She's 16. She don't want to go see her dad every weekend. She don't want to go. She'll go when she wants to go. She won't go when she won't go. And the judge said, okay, well then I'm stopping child support. And he hit that gavel. And let me tell you something. The judge hit the gavel, it's hard it's hard to get there because he didn't hit the gavel. It's over with. He stopped child support because the child was 16. She didn't want to visit, and the mother wouldn't make her. And so, just like that, I mean, it's getting to be more and more no nonsense. So, I want y'all to keep that in mind. And okay, so what do I want to tell you about child support? There's a calculation for child support. In Tennessee, a lot of states do what's called income shares. And so they're going to take the income of both parents and put that together. And then the statute says, look, if you have one child, if there's 2 children, if there's 3 children, a certain percentage of the income goes towards supporting those kids, right? So, but they're going to come up with a number. It almost looks like a tax return, how they do the math. And they're going to come up with a number that says, for this one kid, it costs $893 a month to take care of this child. Just say 2 people are divorced and they have 1 child. It costs $893 a month to keep this child in the lifestyle they were living in. Now, of course, if it's Michael Jordan's kid, it may take $10,000 a month. But, regular people, $893. And then they'll say, based on incomes, parent one, you have to pay 60% of that cost, not your income, the cost to take care of the child, the $893. You have to pay 60%. Parent two, you got to pay 40% of that number. Okay, so how you calculate support, that's in the statute. And I want to point out something. So remember when I said there is a theme that runs across, the United States in terms of these laws. So there's something called the Uniform Interstate Family Support Act. The lawyers will call it UIFSA. And if you've been through this, you might have heard your lawyer say UIFSA. The Uniform Interstate Family Support Act is basically a set of model laws. It's a set of laws that all states who have signed on to, which is most of them, agree to follow. Which is like, hey, that's why now if you move from one state to another state, you can get your order registered in a new state, the child support or transfer, this, that, and the other, because the states are working together with one uniform set of laws in order to facilitate collecting child support, enforcing custody orders, and different things like that. So let me make sure there's no question before I go to take a break. And I don't see any, but so what you need to know about child support is if you don't agree to it. Remember I said with my divorce, we agreed to no child support and all this other stuff, right? So if you don't agree on a number, on a way to pay, or whatever it is you agree to, and you have to have the court decide, the court is going to go by the statutes. So actually, to my producer, I'm gonna go 2 more minutes to 6:35, and then we can take a break. And then when we come back from the break, I'm gonna share my screen with these statutes so you guys can see what it looks like. I will tell you that in the state of Tennessee, it's Title 36. That's where you're gonna find all the laws about marriage, divorce, and custody. In Mississippi, it's Title 93. That's for all the laws about marriage, divorce, and custody. So when we come back and I'll share my screen, I'm going to show you guys where the laws are and where to look at, because they're not really, some of them may be a little complex to read, some of them, but most of them, they're just an easy read. And you'll see why the courts are doing what they're doing and why the judges, the lawyers are telling you what they're telling you, because it has to go down the way that it is in the statute. So what we do is usually halfway through, we take a break. We take a music break. It's a few minutes. It's 4 minutes, but I always say that's a chance to, go to the bathroom, get your notes caught up, see if you have a question for me, and be putting the question in the comments, and I can be working on the answer, and just kind of a chance to regroup. So we'll do the song now, and then on the other side, when we come back, I'll show you all these statutes.
Alrighty. Good evening, everyone. Just to let you know, the 2 QR codes, the one in the top corner is for you to set up a consultation with Attorney Nichon. And if you would like to donate to her, the Cash App QR code is right there for you to do so. Alrighty. So what we do here at Blast is we like to support independent artists all around the globe. And tonight, we have an artist that is based in North Carolina. Her name is Demi Day, and this is called Be Like You. Let's check it out.
Everybody can't reach like, everybody can't dream like, everybody can't be like, everybody can't be like you, everybody can't reach like, and everybody can't dream like, everybody can't be like, Everybody can't be like you. I understand you got your own thing going. Merely on down the stream, you better keep on rowing. They try to knock your self-esteem, you better keep on glowing. Don't let nobody in between that future you be knowing. So here's my message to you. Ain't no person on earth that can outdo you. Be yourself until yourself. You'll be honored that you knew you. Only you can be a rock when it ain't no one else around. And if you don't love yourself, then the only way is down. But I believe in you. I see you got some dreams in you. Full speed ahead, I see you got some steam in you. Just keep chugging away. Be grateful for every day that you get to bless the world with such a beautiful face. Let your shadow make the chase. Let your heart dictate the pace. Let your mind give you the strength and let your spirit run the race. And bet your ancestors cheering, seeing the path you clearing. Nothing worth fearing, every lesson worth hearing. But every now and again they try to break you. Lean into them wounds even though they might be painful. And when they heal the scars, that's when you gon' see a breakthrough. I'm praying that you make do with every resource within your grasp. Multiply it forth and be generous with your math. Kindness in your hand, willing to understand that every single second you get is another dance. And every single moment you breathe is another chance to do something you love, to always rise above. Parting for the past, don't let that trauma beat you up. Be gentle with your mental and everything you done been through. End of the day, you're the reason I grabbed a pencil, so I could draw you up a motivational stencil. Tracing the inspiration, make way for the destination. 'Cause trust me, I can see all of the places that you're headed. And I'm here to let you know you ain't gonna never reach a dead end. Everybody can't reach like, everybody can't dream like, everybody can't be like, everybody can't be like you. Everybody can't reach like, and everybody can't dream like, everybody can't be like, everybody can't be like you.
And that was Demi Day with Be Like You. And if you are an independent artist, a spoken word poet, or an up-and-coming comedian looking for some exposure, you can go to blastmusic247.com and register for free. But Blast is also looking for the fans. So if you're a fan of great music, you too can go to blastmusic247.com, register as a unlimited fan, and get access to hundreds of independent music. Blast, we're constantly changing the industry one artist at a time. All right, Nichon, back to you.
Hey, yay. Okay. He always picks good music. Okay. So there is a question. What if a parent pays child support and the other is able-bodied but refuses to work? I was just reading a statute on that before we came on. And so there's the whole refusal to work. There's being underemployed and there's being unemployed. Now, generally how it works across the country, and I just looked, Tennessee has a specific statute on it, and Mississippi does too, but generally how it works is the court can do a few things. One thing is called imputed income. So I have friends and people call all the time to say, he working, but it's off the books, or he won't work, or something like that. So what happens with imputed income, and I'm sorry, y'all, it's that time of day and the sun is coming through. But what happens with imputed income is the court is going to look at what is that person's potential to earn and impute that amount of income to them. So say for me, for example, if I'm under order to pay child support and I'm like, I ain't paying, I'll quit working before I pay child support. We know people say that, right? So say that goes on 6 or 7 months, and then the father takes me to court and I was like, Your Honor, I'm unemployed. And they'll look, give or take a few months at the prior 24 months, or they'll look at the degrees I have, the community I live in, my ability to get a job. And I'll say, you know what, you might be unemployed, but you have the potential. Lawyers on average in this community make $80,000. And you have the potential to make $80,000. So I'm setting your child support based on the $80,000. That's called imputed income. They're going to impute. Now, the statute I just looked up said, if the judge has no basis to impute income, like has no information to go off of, that the person has to pay like 75% of the federal poverty limit. You know, some jurisdictions say that the person is charged with at least making minimum wage and they got to pay child support based on that. The biggest thing I would say is have proof about the person's status. If they're working off the books, try to find a way to prove that. And the other thing, if they're working off the books, sometimes, look, this is cruel for me to say, but sometimes what you got to do is call the IRS if they're working off the books. Sometimes you like, I can't get you, but these alphabet boys over here, IRS, they can get you. And they'll be more than happy to investigate what's going on off the books. So there's more than one way to skin a cat is what I'm saying. And sometimes you can't get to them, but there's another way to get to them. But imputed income or the statute will tell you how to get that person paid. So the problem is you already have an order. So what if a parent pays child support and the other is able-bodied but refuses to work? The court, you need to go to court with some evidence about his ability to work, what he can do, what degrees he got. The court will ask him questions, do all that kind of stuff. You need to get your order modified based on imputed income or based on any other calculation that the statute provides for. And I think I might have to click this share button first right here. Let me see. Okay. Share screen. Tennessee go. Okay, this is what I'm gonna do. Wait a minute. Why does it keep jumping? Share. I want to show y'all this. Hopefully y'all can see it. I want y'all to put a 1 in these comments if y'all can see this screen. And if it's too small, somebody say it's too small. If it's too small, it's gonna be unfortunate. You see this says Illinois statutes, chapter 750, families, allocation of parental responsibilities and parenting time. This statute right here is a really good example. Illinois statutes, chapter 750, families, section 5-602.7. It's about parenting time and parental responsibilities. How the court determines who the child is going to live with, the factors that they consider. And it can range from, look, I'm going to tell you what's really important. What courts are looking for these days. Which parent is going to foster an environment of helping the child connect to the other parent, the non-custodial parent. If you're bad-mouthing a parent, that's not going to work. The court is not going to stand for it. They've been cracking down on that over the past decade. So that's a factor. Hold on, let me see if I can. Okay, which parent can give the child the most stability? Which house the child is most comfortable at? Now look, in Mississippi, the age is 12. If the child is 12, the court will take the child in the chambers and say, who do you want to live with? And will give heavy weight to what the child says. I've seen some statutes in some other jurisdictions, and they don't have an age limit on it. They just say the court can pull the child in chambers and can ask the child who they want to live with or where they want to be at. The court is going to pull the child in chambers so neither parent knows what was said. And I would encourage you, don't ask the child what was said. Because if the court finds that out, that can be bad. She said print too small. Okay. But okay, you guys can't see it. I'm sorry. I'm gonna have to have like another seminar where I can do it like a Zoom or something. But I just wanted y'all to know that there are actual statutes that control all the things that happen. And what you really want is for a judge to make findings on the record, because the judge's findings is going to determine why they did what they did. The judge is going to say, I find the mother is a more suitable parent for this reason. She has maintained stable income for the entire life of the child. She has maintained a home for the entire life of the child. Blah, blah, blah. Like the judge will list their reasons. Usually by law, they have to do that. So I always encourage you have to have your proof and your evidence together when you go to court. Do not go to court and say, oh, he smokes weed around my child without any proof. Because these statutes, this one you can't see in some of the other ones, they start out by saying, the The court has to presume that both parents are fit parents. The other thing you should know that your right to be a parent is a constitutional right, and it's a fundamental right. Whenever somebody has a fundamental constitutional right, it's hard to get rid of it. And that's why it's hard to, a lot of times it's hard to terminate somebody's parental rights because you have a constitutional right to be a parent to your child. So even the parent that you don't like, they got a constitutional right to be a parent to the child. The law tells the court has to presume that both parents are equally fit to be parents. So the presumption is always going to be joint legal custody. And then physical custody will be primarily with one parent, and then the other parent will have visitation. So the default is always going to be joint legal custody. Real quick, I wanted to run down, and I see there's 2 questions. Give me a quick second, and I'm going to cover those. But I wanted to real quick run by some interesting Tennessee statutes that I saw. And this is one thing I know. So you guys, I used to be an administrative judge, a hearing officer in the state of Tennessee, and child support was one of the things I did. And what a lot of people don't know is if you have multiple children and the first one hits 18, child support don't stop automatically. You have to go and you have to petition for a modification. And then you say, hey, this child has aged out. It tells you in the statutes what aged out, what a grown child is. Most of them will say that they're either 18 or they are over 18, still in high school, and haven't reached their 19th birthday yet. Except in Mississippi, they're 21. Now, in Mississippi, you can emancipate a child by if they get married, if they go to the military, if they go to prison. I believe it's for longer than a year. That emancipates them, and you don't have to pay the support even if they're not 21 yet. But if none of that, if they're not married, they're not in the military, they are not an adult till they're 21, you got to pay support until then. But once that child hits that age, you have to go to court and get a modification and say, hey, okay, release me from this responsibility. Stop that child support. If you don't do it, you're gonna pay until you go and do that part. You're gonna still be charged with it. Okay. And so in Tennessee, what I just explained to you, that's 36-5-503. 36-5-104 says you can go to jail for 6 months for not paying. You got to either pick up trash or, your driver's license gets suspended, or you got to go clean up parks or go do something like that. So there is a penalty. 36-5-105, that's just for those of you getting alimony. If your spouse dies, you can still get the alimony from their estate. Talk to your lawyer about that. This is one that people get wrong too. 36-6-108. If you're a parent and you relocate more than 50 miles away from the home, you have to get the other parent's permission. If you don't get that other parent's permission, if they don't agree, then you got to go to court and get the court to give you permission to move. A lot of people move and they don't get either the other parent's permission or they don't get court permission. Even if you're moving, like if you voluntarily moving because you're like, okay, I want to live somewhere else and I'm gonna find a job there. Sometimes some people jobs transfer them. Some people are in the military. Now that's a little bit different. Of course, the court is going to prove that. But if you just decide you're going to pick up and move, you got to have the other parent's permission. And if that parent won't agree, then you're supposed to go to court and the court is supposed to give you permission to move. People mess that up all the time. And that's how things really get off track with visitation and the child support amount. Tennessee has 36-6-113, which is failure to return a child. People will get a child, whether it's visitation or whatever way they lawfully came into custody of the child for a brief period of time, and they won't return the child. That's unlawful. And then there's also mechanisms to get the child back, even if the child is removed to another state. That uniform law that I told you about, there's mechanisms inside of there where you can take your order from the state you and your child live in. Say you live in Tennessee, but your child goes to California to see their father. Father keeps the child. You take your Tennessee order and you go to California and they will enforce it there. because of this uniform interstate law that I told y'all about a little bit earlier. So, as y'all can see, this area is very vast. I wanted to use this time to discuss things that people often get wrong, that people call me about and I hear about. Of course, nobody would think, somebody's not like, I ain't ready to get his permission to move. You gotta, by statute, you gotta have their permission to move. If they don't give it, you're supposed to go to court and get the court's permission to move, and then all that stuff is redone. Let me handle some questions. Let's see. Can you have private agreements? When can you enter one? When can't you? Can you enter mediation at any point if both agree? Okay, so yes, the private agreements is what I kind of meant in the beginning when I said you all need to agree. That's a private agreement. So you want to have that. You want to have a private agreement that it ends up being written on paper, and you can keep it under seal. You can keep it private. The filing will just say the parties have come to an agreement. It's represented in a property settlement agreement, and this matter is closed. And then it won't be like in a public record. Okay, when can you can enter a private agreement at any time. So say you've been under a court order and y'all are just tired of fighting and going to court. And so maybe y'all are 5 or 6 or 7 years older now, and y'all have a different perspective. And you can say, hey, can we sit down and let's talk about this? Then you will go back to court and ask for a modification and say, hey, for years, we've been under this agreement that the court ordered, but the parties have now come up with an agreement that they can live with. And we're asking the court to now accept our agreement and get rid of your agreement, court, because we just don't want to do that no more. You can do that. I don't know that there's a time when you can't. I can't think of one right now. Okay, can you enter mediation at any point if both agree? Yes. Mediation is out now. I mean, because there's voluntary mediation, there's court-ordered mediation. So yeah, you can always privately hire a mediator and say, hey, we can't get along, and then just, and work it that way. So yeah, you can do that at any time. Okay. What if there was a verbal agreement of split custody, nothing on paper, and now the non-primary parent is filing? Let me see. So what if there's a verbal agreement to split custody, nothing on paper, and now the primary parent? I mean, okay, so you'd have to have some kind of proof or evidence of the verbal agreement. You can tell the court, hey, we had this agreement. This is why we're operating right now the way we're operating, because we had this agreement. And it depends on what the parent that's filing, what are they now asking for? If you had an agreement to split custody, do they now want full custody? What is it that they want? And it may be that you can still work that out and bridge the gap between what you agreed to and what they want. But once again, that's just a consideration of, do you want to try to agree yourselves, or do you want the court to impose all of these laws and these statutes? You have to think about that. So you'd have to kind of have some kind of proof. I mean, once you do a verbal agreement, you're kind of out there if you don't have any proof. So, some people get skittish. They don't want to write stuff down. If somebody wants to agree with you verbally and they don't want to write it down, you already should be suspect. That's already suspect. If you're willing to agree verbally, why are you not willing to write the same thing down on a piece of paper? So, okay, let's see. When a parent who is court ordered to maintain health insurance for the children fails to do so and delays disclosure, requiring a custodial parent to secure coverage independently. I guess when a parent who is court ordered to maintain it fails to do so, delays disclosure, requiring a custodial parent. I mean, that's the thing that I said earlier. You want to go, so you don't want to let stuff go too long. That's why I said 1, 2, 3 instances. File a motion for contempt or a motion to show cause. Once again, keep your lawyer paid. That's part of your planning. You're going to have to go back in the court and say, hey, he's not paying. I've had to add them to mine. So now I need more child support. Or, something like that. You're going to have to go in and find him in contempt. And then you can get contempt remedies for that. But that's the problem with this. When you don't agree and the court says something, you have to keep going back. If the person won't do what it is you need them to do, the only way to make them do it is to make them go in front of the judge and explain themselves to the judge. But in that case, if somebody is supposed to maintain health insurance and they're not, you got to go and hold them in contempt. If you end up getting the health insurance, now you want to ask the judge for increased support or for some other remedy that'll make that better. When it comes to relocating outside the 50 miles, is it required to provide the exact new address in order to obtain permission to move? You know what? I'm glad someone brought that up about the address. Usually, the general standing order is parents are entitled to know where their children are. You have to give the other parent your address. The main 100% exception to that is if there's a protective order because of domestic abuse. Now, the parents are entitled to the address. They're entitled to know where the child goes to school. They're entitled to school records. They can go up to the school without the other parent, put their name in the records. They can talk to teachers. They can go up to the doctor's office and put their name in the record there. They can do all of that. To the extent you stand in the way of that, you hinder your case to be the custodial parent, and the judge may or will change custody. Remember, I said the law makes the judge start from the point that both parents are fit parents. Just because the one parent has custody does not mean they running everything. The other parent still has 100% of their legal right to be a parent. So to the extent you interfere with that, you put yourself in jeopardy of being disfavored by the court. So the judge is going to want to know where if you don't have an exact address yet, you can just say, like when I moved from Nashville to Dallas, well, Your Honor, I'm relocating to Dallas because I'm over Nashville. You know, I'm done with Nashville and I'm ready to go. Okay, Your Honor, I don't have an address yet. I'm actively looking to relocate. And the judge will say, okay, and then they'll go through whatever analysis they go through. The judge will say, okay, yes. But then when you get there and you get the address, you got to update the other party as to the address. The other thing is, if you are the person who decided to move, then the court can, and a lot of times will, make you be the person to transport the child to the parent that you moved them away from. Keep that in mind. It may also, if it's going to reduce their parenting time, it may reduce your child support. Keep that in mind. So a lot of things can happen with this move. So if it's not for work and because remember too what I said, the court is trying to maintain the situation that existed before y'all split. And if you move away, that's going to hurt the other parent's opportunity to see the child as much as they were like when you were living in the same place or whatever. So keep that in mind. A lot of people get that wrong and they think, well, so they'll move and then they say, well, I mean, I can't afford all these plane tickets or I don't have the time to shuttle them back and forth or whatever. But the court is going to squarely put that in your lap. Now, the court may not order you to pay for both ways, but the court might order you to pay for both ways. But when you go and ask for permission to move, that's when the court is going to take up these expenses, what that means, you know, and if it's drivable distance, then they'll work out the schedule for drop off and all that kind of stuff. So whenever you do the petition to move, that's when all that'll be discussed. I don't see, let me see if I saw any other interesting, y'all, there's a lot out there, as you can tell, like, because we're at an hour and I didn't even get to cover everything I wanted to cover. The important thing is to know that it's statutory driven. A lot of what I said, especially, look, I don't even want to say that because a lot of times AI and Chat GPT be wrong, but I want y'all to know that there's a place that you can go, just type it in, where Tennessee code annotated, and then it's a free website where you can go and you can see the laws. A lot of it is easy to read where you can read it yourself, but I would encourage people to come up with an agreement and to take the fighting out of the courts. If they see you fighting, if you look like you difficult to deal with, it's not going to go in your favor. And I always tell my clients, don't be the problem and don't look like the problem. Make the other person look like they the problem. you know, come to court ready to comply, ready to do what's necessary, but also come knowing that, you know, like I said, just because whoever the custodial parent is, they don't hold all the cards. And you have to, especially if you have a parent on the other end that's going to force your hand to do what it is you're supposed to do. And then I would say force their hand too. If you have somebody that's not paying support, you have to decide, do you want to go down that road of trying to make them pay? Because that can be a very difficult road. And that's why you want to plan it out from the beginning. You already know the person that you was with. They either going to pay or they not going to pay. You already know what you're working with. So you have to decide how much time do you want to spend fighting about that. And that all goes into the planning. Let me see. Okay, no, I don't see. I thought that was a new question. Okay. So I hope this has been helpful. I probably have to do another one and break it down and just do just divorce and then just custody and then just child support, because there's so much to it. But I hope these big themes that I told you guys about, I hope that is what sticks with you about have the agreement and know that both parents have equal rights, and know, about custody, that it's not automatically in the woman's favor anymore. And courts are really, really looking at that. So, we didn't even flash my number up. The 615-596-3132. And then, so you guys call me or send me an email. You got it? Okay, yeah. Send me an email, and then I can answer your questions if you have more specific questions. I thank everybody for the messages and for liking and for jumping on. And this hour went really fast. But I think I got everything. Okay, so next week is, I believe it's life insurance and health insurance, but a lot of people ask me questions about life insurance, how much to get, what kind to get, when to get it, how to get it, all that kind of stuff. I'm going to answer those questions. And then future podcasts coming up real soon are going to be how to start an LLC, how to start a S Corp, a corporation, or a nonprofit. So how to start a business. I'm going to do how to read a contract. And that's really mostly like leases. When you buy a car, in any of the common contracts people enter into every day, I want to tell you how to read those and how to do that. And so those are a couple of ones that are coming up in the future. So, make sure you subscribe. Thanks so much. I hope everybody enjoyed it, and just contact me if you got questions.